This is the Baker Act Guardian Advocate Training, Module 1.
He's coming up with paranoid schizophrenia. He's hearing voices that want him. He wants to kill himself.
Mr. O'Brien, have you been here before? When was the last time, roughly? April. Which unit?
18 each.
I'm going to give the clerk your papers.
The guardian advocate is basically the voice of the individual held in a mental health treatment facility. A guardian advocate is the informed decision maker for an individual found by the court to be incompetent to consent to their own mental health treatment. The court may authorize a guardian advocate to make general and/or specific medical decisions for that person. This course of instruction provides the necessary information to carry out the guardian advocate duties. In this module, I'll define guardian advocate, review the Baker Act process for voluntary admission and involuntary commitment and transportation, define express and informed consent, and identify the types of responsibilities of a guardian advocate appointment. Let's begin with an overview of the Baker Act and the role of the guardian advocate.
So my brother continued down his path of complete depression. I continued to say my brother was bipolar, but he would not get treatment. He continued to just drink and drink and drink, and he finally one night just had said enough. He kept telling me he was going to commit suicide. I would get texts from my niece, kept saying Daddy's going to kill himself. Finally in September, my brother actually went out and made the attempt to try to asphyxiate himself by putting hoses in his car exhaust and sitting out where his wife was killed in the spot and trying to kill himself. So we had my brother Baker acted.
The definition of mental illness under the Baker Act 394.455 subsection 18 of the Florida statutes reads, an impairment of the mental or emotional processes that exercise conscious control of one's actions or of the ability to perceive or understand reality, which impairment substantially interferes with the person's ability to meet the ordinary demands of living. For the purposes of this section, the term does not include a developmental disability as defined in Chapter 393, or intoxication, or conditions manifest only by antisocial behavior or substance abuse impairment. It's important that you understand and know that definition of mental illness, because to be Baker acted, both the criteria that I just read need to be in place. The clinical component, meaning an impairment of mental or emotional processes that exercise conscious control of one's actions or ability to perceive or understand reality, and that functional component, meaning it substantially interferes with a person's ability to meet the ordinary demands of living. Here is a flowchart of the Baker Act process for both voluntary and involuntary admission. Marked in blue are where guardian advocates might intervene in the process on behalf of the individual or ward that they serve. A person can be on voluntary or involuntary status under the Baker Act. However, to be on voluntary status, a person must not only be willing to consent, but competent to consent to admission and to treatment. If a person is incompetent to consent to treatment, then they can't be held under the voluntary provisions of the law. Incompetent to consent to treatment means that a person's judgment is so affected by their mental illness that the person lacks the capacity to make a well-reasoned, willful, and knowing decision concerning their medical or mental health treatment. A person on voluntary status is presumed to be able to exercise all of their rights under the law, including that of consenting or refusing consent to admission and or to treatment.
Intervention
Okay.
center and talked to them on the phone. They said there was nothing they could do for me for one night. So I wound up here by ambulance. Paid an ambulance to take me here.
Okay.
Because the crisis intervention couldn't do anything for me.
Have you ever made any suicide attempts?
Oh yeah, I have. A couple of them when I was 19.
Okay. Are you usually able to ask for help when you start feeling like that?
No, I was never able to ask for help before.
Okay, so this is a new thing.
This is a
You're
new
coming
thing
into
for
the
me.
hospital.
Yeah,
Okay.
the way I came in here is unlike any other way I've ever come into a hospital. Asking people to please help me so I do not kill myself.
That's all the questions I have for
Okay.
right now.
Can I go back in now? Yeah, I'm getting very uncomfortable out here. I think somebody might be trying to shoot me. Someone might be trying to kill me.
The Baker Act encourages the voluntary admission of persons for psychiatric care, but only when they're able to understand the decision and its consequences and are able to fully exercise their rights for themselves. To be admitted under voluntary status, the individual must show evidence of mental illness, be competent to provide express and informed consent, and be suitable for treatment. Such a person 18 years of age or older may be admitted to the facility at that point. Each person entering a facility, regardless of age, must be asked to give informed and expressed consent for admission and treatment. Let me make it clear that there's only one professional who can determine competency for a person to sign into a facility on a voluntary basis. In reading over the laws and the rules, there's some contradiction. However, some areas simply state physician, while others state admitting physician. Basically, it is a physician, be it psychiatrist or non-psychiatric physician with training in diagnosis, that can make this determination. The statute, as noted, does define a physician, and as a result, the rules and even the 3104 certification form refers only to, quote, physician. It does not require this function be performed by a psychiatrist unless the receiving facility's policy and procedure are more stringent than that required by the Baker Act law and rules. However, this function cannot be delegated to a physician extender like a PA or an ARNP, and cannot be extended to a psychologist. Within 24 hours after a voluntary admission, the admitting physician must document in the person's clinical record that the person is able to give express and informed consent for admission and treatment. If the person is not able to give the express and informed consent, the facility must either discharge that individual or transfer them to an involuntary status. According to the statutes, express and informed consent means consent voluntarily given in writing by a competent person after sufficient explanation and disclosure of the subject matter involved to enable that person to make a knowing and willful decision without any element of force, fraud, deceit, duress, or other form of constraint or coercion. Remember, each patient entering treatment shall be asked to give express and informed consent for admission or treatment. If the patient has been adjudicated incapacitated or found to be incompetent to consent to treatment, then express and informed consent to treatment shall be sought instead from the patient's guardian or guardian advocate. And if the patient is a minor, express and informed consent for admission or treatment needs to be requested from the patient's guardian.
Implied consent is not sufficient in Florida. Express and informed consent is the legal standard. A person is incompetent to consent to treatment when their judgment is so affected by their mental illness that they lack the capacity to make well-reasoned, willful, and knowing decisions concerning their medical or mental health treatment. To assess if the person is competent, the evaluator will ask questions related to person, ask to state their full name, object, may show a picture of a common animal or fruit, place, ask if they know where they currently are and why they are there, and time, may be asked to state the year and the month.
If the person meets criteria for involuntary exams, such exams should be initiated by an authorized person rather than holding that person under voluntary status with no intention of allowing them to leave if requested. If a person just simply signs any paper that's placed in front of them, then this is implied consent, and it is not sufficient under the Florida Express and Informed Consent, which is the legal standard. If an individual is willing to do whatever they're instructed to do, then that is not informed consent. But it goes back to that implied consent, which is not sufficient. If they are willing to swallow any medication that's placed in their hand, then again, this is implied consent, and it is not sufficient in Florida. Express and informed consent is the legal standard. If they have a window of lucidity at the time of admission that is not continuously documented during the course of their treatment, then again, this is implied consent and not sufficient in Florida. Express and informed consent is the legal standard. Individuals of all ages are protected by the Baker Act from birth to death. There's no difference in how the Baker Act is applied to person based on age except for the voluntary admission of minors and the heightened protection offered to elders on voluntary status who live in licensed residential facilities such as nursing homes and ALFs. The special provisions of the Baker Act for this long-term care population will be identified throughout this course by the LTC banner in the upper left-hand side of the screen. The Baker Act specifically states that the following persons cannot be sent on a voluntary basis to a receiving facility until after an initial assessment of the resident's ability to give express and informed consent is conducted at the sending facility by an authorized independent professional. These residents include a person 60 years of age or older for whom an emergency transfer is being sought from a nursing home, a person that is 60 years of age or older with a diagnosis of dementia for whom transfer is being sought from a nursing home, an assisted living facility, an adult daycare center, or an adult family care home, or a person for whom all decisions concerning medical treatment are currently being lawfully made by a healthcare surrogate or designated proxy. The term guardianship describes a legal relationship between the guardian and the ward. The term ward describes a person whom the court has declared legally incapacitated and has had some or all of their rights removed. It is important to understand that the guardianship should be a last resort and established only in cases where lesser restrictive means of intervention are not possible. There are some individuals whose mental illnesses are so severe and last so long and cause such dysfunction in their lives that nothing short of guardianship will do in order to provide the person the protection of the court. While it's difficult and can be somewhat expensive to obtain a guardianship, Often petitions are filed with the court for, quote, lack of capacity, unquote, as a result of DCF protective investigations. If there's a conflict between the rights of the guardian under Chapter 744 of the Florida statutes and the rights of a person under the Baker Act, the Baker Act prevails according to the appellate courts.
Program here that I learned if I went in and I showed my badge at the counter, when they would argue with me and they would say, no, I'm sorry, you can't come in, visiting hours are 9:30 to 3:30, I would actually say, no, I'm sorry, I have this guardian advocate badge and I can go in and see it. Now I can actually pull it out and show it if you want me to put it on the camera.
Rarely will a long-term care facility resident with the capacity to make well-reasoned, willful, and knowing decisions about his/her medical or mental health treatment require transfer to a Baker Act receiving facility for examination and treatment. An independent professional must evaluate the resident's capacity to provide express and informed consent prior to transfer to a receiving facility. The only other alternative is to have an involuntary examination initiated by the physician or other authorized mental health professional associated with the long-term care facility.
That initial assessment can only be performed by one of three of the following: a mental health overlay program, a mobile crisis response team, or a licensed professional who is authorized to initiate an involuntary examination and is employed by a publicly funded community mental health center. If none of those above services exists nearby, or if the service cannot respond within 2 hours of being called, then the facility may contact a licensed professional that's authorized to initiate an involuntary examination. That person cannot be employed by or contract with either the facility initiating the transfer or the Baker Act receiving facility to which the individual may be transferred. Nor can they have a financial interest in either of the facilities. Another group that can assist with this voluntary admission for long-term care residents is a mobile crisis response service. This is a non-residential crisis service that's attached to a public receiving facility and available 24 hours a day, 7 days a week, through which immediate intensive assessment and intervention, including that screening for admission into a receiving facility, takes place for the purpose of identifying appropriate treatment services. That third group that can perform the voluntary admission initial assessment is a licensed professional who is authorized to initiate an involuntary examination and is employed by a publicly funded community mental health center. A community mental health center or clinic is defined as, again, publicly funded, not-for-profit center which contracts with the department for the provision of inpatient, outpatient, day treatment, or emergency services. Express and informed consent requires that a person on voluntary status be competent to make well-reasoned, willful, and knowing decisions concerning their medical or mental health treatment. Consent must be voluntarily given in writing after sufficient explanation of the need for admission so that the person can make a knowing and willful decision without any element of force or deceit. If residents cannot meet these criteria, then they cannot be on voluntary status in a Baker Act receiving facility, and instead they must be handled under the involuntary provisions of the law if they meet the involuntary standards. The Baker Act encourages the voluntary admission of individuals for psychiatric care, but only when they're able to fully understand the decision and its consequences and are also able to fully exercise their rights for themselves. When this is not possible due to the severity of the person's condition, then the law requires that that person be extended the due process rights assured under the involuntary provisions of the law. A guardian advocate may be appointed for an individual who is incompetent to consent to his or her own mental health treatment at the time of the involuntary placement hearing. They may also be appointed to consent to medical treatment at the involuntary placement hearing. A guardian advocate may be given additional specific authority at a separate special court hearing to consent to any of the following: an abortion, sterilization, electroconvulsive treatment, psychosurgery, or experimental treatments that have not been approved by a federally approved institutional review board. There were 181,471 involuntary examinations initiated in the calendar year 2014 in the state of Florida. Counts of involuntary examination initiations for the last 13 years are reported, and the percentage increase from each year to 2014 is also reported. For example, the number of involuntary examination initiations increased 81.89% from 2002 till 2014. The increase from 2013 to 2014 was 5.66%. The increase in the numbers of involuntary examinations initiated in Florida is greater than the population increase during this same period of time. This is a flow chart of the process for involuntary commitment. As you can see, it's very arduous, and the detail is beyond the scope of this introductory course. I'll discuss everything up and to including the person examined by the physician for their competency to consent to treatment. This does give you some idea of the precautions that are built in the system to protect the individual's rights. A person may be taken into a receiving facility for involuntary examination if there is reason to believe that he or she is mentally ill as defined in the law. Because of their mental illness, 1, they've refused a voluntary examination after conscientious explanation and disclosure of the purpose of that examination, or the person is unable to determine whether they need the examination. And 2, without care or treatment, the person is likely to suffer from neglect or refuses to care for themselves. Such neglect or refusal poses a real and present threat of substantial harm to their well-being, and it's not apparent that such harm can be avoided through the help of willing family members or friends or the provision of other services. Or there is substantial likelihood that without care or treatment, the person will cause bodily harm to themselves or others in the near future, as evidenced by their recent behavior. Before giving consent to admission or treatment, the following information must be given to the person or to their legally authorized substitute decision maker: the reason for admission, proposed treatment including proposed psychotropic medications, the purpose of the treatment, alternative treatments, specific dosage range for medications, frequency and method of administration, common risks, benefits, and common short-term and long-term side effects, any contraindications which may exist, clinically significant interactive effects with other medications, similar information on alternative medications which may have less severe or serious side effects, potential effects of stopping the treatment, appropriate length of care, how treatment will be monitored, and disclosure that any consent for treatment may be revoked orally or in writing before or during the treatment period by the person legally authorized to make healthcare decisions on behalf of the individual. An involuntary examination may be initiated by one of three ways: a circuit court judge, a law enforcement officer, or an authorized mental health professional. Definitions of mental health professionals are specified in the Baker Act. One cannot rely on the definitions in the licensing acts. The definitions are as listed on this slide. Some of the definitions of these professionals in the Baker Act are not consistent with those in licensing statute. When general laws, like the licensing laws, are in conflict with a specific law, like the Baker Act, then the specific law takes precedence over the general law. In other words, definitions presented here are the ones to use for mental health professionals authorized to admit patients on an involuntary status.
If a resident in a nursing home demonstrates aggressive behavior, verbal or physical, and a potential for being an imminent threat to themselves or others, the nursing staff are to notify the director of nursing or designee or the unit manager and or RN of record for assistance with further assessment of the situation and assessment of the current health status of the resident.
Be certain that the administrator or designee is aware of the possibility of an involuntary admission for psychiatric examination, that is, the Baker Acting. Keep the primary physician and responsible party notified and kept informed throughout the course of the treatment and until the situation has been resolved. Notify social services for therapeutic interventions and direct involvement of a behavioral management plan for the resident.
When deciding whether or not a resident should be Baker Acted, first ask yourself and or staff members several questions. Has the crisis intervention plan been implemented? Have all measures been taken to de-escalate the resident, such as empathetic listening, active listening, validating the resident's feelings? Is there one staff member who the resident has a great rapport with on duty to talk with them? Are they an immediate danger to themselves or others? If so, how? Having a resident of an ALF or nursing home Baker Acted can be very stressful for that person. It is important to take all steps possible to avoid sending them to a receiving facility, as this can add to their agitation. The purpose for asking the several listed questions is to ensure the resident is not being sent to a receiving facility because the staff is tired or does not want to deal with that resident any longer.
The role of a Baker Act receiving facility is to provide psychiatric evaluation and short-term psychiatric treatment for individuals in acute mental health emergencies. If the resident requires something different than the psychiatric exam or short-term psychiatric treatment, then they should not be sent to a receiving facility simply because of behavioral problems or to evade federal and state discharge or transfer requirements. Instead, the resident should be directly transferred to a more appropriate type of facility.
Until now, your ward has received excellent medical care from his physician and other healthcare staff at the receiving facility. However, on your last visit, you learned that your ward has been switched to a new antidepressant with no explanation or notification. As far as you can tell, there are no harmful side effects from the medication. Does the lack of communication in this one case warrant complaining to the facility or physician? Yes. Doctors and or medical professionals have the obligation to inform a guardian advocate of the ward's treatment plan. Depending upon the type of guardian advocate appointment, this would include medication changes and diagnostic tests or procedures.
A person can be taken to a Baker Act receiving facility for involuntary examination if there is reason to believe that they have a mental illness as defined by the law, and because of this mental illness, that individual has refused examination or is unable to determine whether examination is necessary, and without care or treatment, that resident is likely to suffer from neglect or refuse to care for themselves. Such neglect or refusal poses a real and a present threat of substantial harm to that individual's well being, and it is not apparent that such harm may be avoided through the help of willing family members or friends or staff, or the provision of other services. There is a substantial likelihood that without care or treatment that the person will cause serious bodily harm to themselves or others in the near future, as evidenced by the recent behavior. There are only three methods to initiate an involuntary examination. They are when a physician, clinical psychologist, psychiatric nurse, clinical social worker, licensed mental health counselor, or licensed marriage and family therapist may execute a certificate stating that they have examined a person within the preceding 48 hours and find that that person appears to meet the criteria for involuntary examination, and they state the professional observation. That physician may elect to personally evaluate the resident on site to determine if the resident meets the criteria for involuntary examination. If so, they'd complete the standard CF-MH3052B form. Also, the physician may elect to have the involuntary examination, or Baker Act, coordinated through the services of a clinical psychologist, a licensed clinical social worker, or a licensed psychiatric nurse. The requirements specify that the clinical social worker be licensed or the psychiatric nurse have a master's or a doctorate degree in psychiatric nursing with 2 years' experience under the supervision of a physician. A licensed mental health counselor and licensed marriage and family therapists are also authorized by law to initiate the involuntary Baker Act examination. In any case, the licensed professional initiating the examination must base their conclusions that the individual meets the criteria on their own evaluation and observation of that resident. A person may not be removed from any program or residential placement and transported for involuntary examination unless an ex parte order, a law enforcement report, or a professional certificate are first prepared. A law enforcement officer is required to take a person who appears to meet the criteria for involuntary examination into custody and deliver that person or have them delivered to the nearest receiving facility for examination. There is a duty for the officer to initiate the involuntary examination if the officer believes the criteria are being met. The officer must take the person into custody for that involuntary examination. There is no expectation for law enforcement officers to be diagnosticians. They are expected to know what a well-trained officer should know, and no more or no less. The Baker Act does not require a law enforcement officer to personally observe the behaviors leading to an involuntary examination. It simply states that the officer must describe the circumstances under which the person was taken into custody. If the officer has a credible witness or witnesses, then the officer can document, quote, information offered by others, unquote, and transport the person to the nearest receiving facility. A law enforcement officer is required by law to take the person named in the ex parte order or certificate of a mental health professional into custody and deliver them to the nearest receiving facility for involuntary examination. If that individual is already at a hospital, in which case then the federal EMTALA law places responsibility to arrange safe and appropriate transfer of that person on the sending hospital. The officer is required to execute a written transportation report detailing the circumstances under which the person was taken into custody. The law enforcement officer's transportation form and the mental health professional report and certificate must be made a part of the individual's clinical record. The law enforcement officer must complete the form entitled Transportation to Receiving Facility, CF-MH3100, describing the circumstances under which the person was taken into custody. The Baker Act forbids the removal of a person from any program or residential placement licensed under Chapter 400 or 429 of the Florida statutes, and transportation to a receiving facility for involuntary examination unless a professional certificate or a court's ex parte order or a law enforcement officer's report is first prepared. If the client's condition is such that preparation of a law enforcement officer's report is not practical before the removal, then the report must be completed as soon as possible after the removal, but in any case before the person is transported to a Baker Act receiving facility. If the sending facility fails to properly initiate an involuntary examination, the Baker Act receiving facility must report failure to the Agency for Healthcare Administration, AHCA, by certified mail on the next working day. Regardless of which of these three methods is used to initiate the involuntary examination, law enforcement is responsible for transporting the person to the nearest receiving facility for the examination. A law enforcement agency may decline to transport that person to a receiving facility only if either the county has contracted for transportation at the sole cost of the county, and the law enforcement officer and medical transport service agree that the continued presence of a law enforcement personnel is not necessary for the safety of the resident or others, or in case where the officer requests assistance from emergency medical personnel for the safety of the officer or the individual who's in custody, or if the officer believes that the person has an emergency medical condition. Or third, when a transportation exception plan has been approved by the Board of County Commissioners and the Secretary for the Department of Children and Families. Another exception to law enforcement being the provider of transportation for residents who need to go to a receiving facility would be when a staff of mental health overlay programs or crisis response services have chosen to provide the transportation after doing an assessment at the facility. Here's a quick reference guide to legal authority that the guardian advocate and other professionals are allowed to assume. If the person remains at a receiving or treatment facility for more than 12 hours, then they're to be given a physical exam by a health practitioner authorized by law to give such an exam within 24 hours after arrival at the facility. A patient is then to be examined by a physician or a clinical psychologist at a receiving facility without any unnecessary delay. They may, upon the order of a physician, be given emergency treatment if it's necessary for the safety of the patient or for others. The patient may not be released by the receiving facility or its contractor without the documented approval of a psychiatrist, a clinical psychologist, or if the receiving facility is a hospital, the release may also be approved by an attending emergency department physician with experience in the diagnosis and treatment of mental and nervous disorder, and after completion of an involuntary examination. However, a patient may not be held in a receiving facility for involuntary examination longer than 72 hours. That mandatory initial involuntary examination must include a thorough review of any observation of the person's recent behavior, a review of the document initiating the involuntary examination and the transportation form, a brief psychiatric history, and a face-to-face examination of the person in a timely manner to determine if that person meets the criteria for release.
Your ward has stated that he is embarrassed about the fact that he is a heavy smoker and drinks too much alcohol on the weekends. He does not want anyone to know this information other than you. Given your responsibilities as guardian advocate to ensure the well-being of your ward, are you obligated to share this sensitive medical information with the attending physician? Yes. Be honest about your ward's lifestyle, including diet, use of alcohol or other drugs, smoking history, sexual history, and health issues that you are aware of.
This concludes the coursework for Module 1. Are you ready to take the knowledge review? Can you define guardian advocate? Do you know the general criteria for voluntary admission, involuntary examination, and transportation under the Baker Act? Can you describe, express, and informed consent? And are you able to identify some of the responsibilities of a guardian advocate? If so, then you are ready to take that knowledge review. If not, then go back over this module and study what you need to again. Then take the knowledge review. To complete the knowledge review, go back to the M1 tab and click open the Module 1 Knowledge Review. After completing the knowledge review, you may decide that you need additional study of this information. If so, return to the beginning of the module to review it. If you correctly answer 16 out of the 20 questions on the knowledge review, then you may go forward to the next module, Module 2, the M2 tab.